Hello, Todd Smith here with another appellate tip of the week. This week's tip: the first thing you should do when the trial court signs a final judgment. The scenario is this: you're a trial lawyer who won at trial. You had a successful jury or bench trial. And now the trial court has signed a final judgment awarding money to your client, either damages or attorney's fees or so forth. Most lawyers know that you can't go get a writ of execution in that situation right away. A judgment is not enforceable for at least 30 days after it is signed. But here's what you can do as soon as the judgment is signed. You can file an abstract of judgment in every county in which the judgment debtor owns property. That's usually the defendant, but whoever it is that actually owes money under the judgment, you can file an abstract of judgment wherever they may own property. And you can do this even though the judgment technically is not final. You can also do it even if a supersedious bond has been filed or posted. So supersedious doesn't affect it. Finality of the judgment is not a factor. You can do it as soon as the judgment is signed. So a good rule of thumb is to file an abstract wherever the defendant is from, where they have property, where they live, where they work, where their family is located. And you never know, you might actually hit upon some property that you don't know about. Another good idea is to run a property record search using a service like Appellate. That can turn up some good information so you know specifically where you need to file the abstract. Abstracts are pretty easy to prepare. You can prepare the form yourself. It's much like an affidavit, and those are generally available through various services that provide legal forms. And you can probably find one just through a Google search, although no one could attest to the completeness or the reliability of a Google search result on this issue. So, but once you get the form completed, then you should work with the local property records clerk to get it recorded and in the real property records, and then returned to you as the lawyer. Then when the judgment debtor goes to sell real property that's non-exempt, boom, they've got to satisfy your judgment before they can complete that transaction. And that can come in handy too in terms of negotiating settlement for these kinds of cases. So there you go. First thing you do when the trial court has signed a money judgment for your client: record an abstract. That's it for this week's tip. Hope you're able to put it to use, and we'll see you next time.